Okay, we started.
Oh, okay, great. Wonderful. Well, hello, everyone. Welcome to the third webinar of our webinar series, informing the Brazil SEP landscape based on kind of decades of knowledge. The first two webinars were very foundational in discussing the foundation of FRAN, what is FRAN, the significance of it, as well as some core principles outlined in a significant document developed by stakeholders called the CWA 95,000, and applying that to Brazil's landscape. So today, I have the honor of uh, experts around the world that have really dealt with different landscapes that have a very developed view on standard essential patents and the disputes in SEP licensing. So we'll start today with a presentation by David Katz, who is an attorney at PacTech. And David will be presenting on the importance of transparency and fair negotiation practices in SEP declarations and licensing. So David, I will throw it to you.
Thank you very much, Priya. I will quickly throw up my presentation. As Priya just said, I will be. Sorry, is the images of everyone coming up on the side? I'm not quite sure on the screen share, or is it just the presentation?
It should just be the presentation.
Okay, great. So I'll be talking about transparency and fairness in SEP licensing today. So before I begin, I always like to talk a bit about what we're actually dealing with, which are our standards, before even getting to patents. I think this is important for setting the stage and knowing where we're going and what we're talking about. In part because the intellectual property issues that come out of standardization and SEP really is ancillary to the entire mission and goal of standardization itself. So standards, what are standards? Standards are a way of codifying knowledge to set up, and particularly in the context that we discuss them, to establish interoperability protocols. The technology of standards isn't what makes them so important. It is having consensus from the industry to adopt a common language for how devices or programs can interface and communicate with each other. Standards in this SEP context are often come into context in the form of cellular and video codecs and Wi-Fi, but standards really are everywhere. They include how you screwing in a light bulb, the interface between both the electrical, the voltage and current, as well as the threading on the bulb, nuts and screws having standard sizes that anyone can use, train track sizing, so both the gauge of the rail and the train wheel, along with the spacing, is another example of a standard. The electrical outlet, we've all been in a situation where you have a device that is from a different place that isn't interfacing, and you're having to use an adapter, and that gets kind of messy. Another form of standards which aren't operability standards are building codes. This provides information to consumers that a building has been built to a certain amount of specifications and is going to be safe within certain tolerances. So the point is standards are everywhere, and the IP litigation is really part of a narrow subset that has come out of it. So from there, so we need to look at also how standards are developed. Standards are made at standard development organizations, and when they're developed, they are made by a diverse range of stakeholders, but those stakeholders are often led by industry representatives, and they operate on a consensus process for making technical decisions. These technical committees will often have multiple solutions in how to address a problem, which can be a very small subset of a much bigger standard. And they will ultimately select which solution they want to adopt. Companies have a lot of benefits from participating in standardization. It helps them develop their technical competence in the standard, so they actually know how it will how to integrate it into their products. And it ensures that their interests are considered in the standardization process. If one side of an interface, so in the context of cellular, if the network equipment manufacturers were to be in charge of the entire standardization process, they could push all of the costs of upgrading or changing onto the device side, or vice versa. But by having all interests represented, the most efficient way solutions are able to be adopted. It also signals their commitment to investing in a common technology, which means that consumers are able to have some confidence that the standard will be supported by industry going forward, which creates security for buying. Now, when I started looking at standardization and standard essential patents, as a young lawyer, my initial thought was that the way standardization worked, where a bunch of companies come together, they bring their proprietary technology as ingredients and sort of throw it into a big soup. That was not correct. That is not how standards are made. Standardization and standards are developed through more of a collaborative process of engineers coming and identifying problems, going and finding solutions to that problem and then bringing them back. It is not is not a combination of secret ingredients. It is more of a group project where the best or optimal solutions are ultimately selected. And ideally, that's the case. Another important thing to recognize is that when we talk about standard essential patents, is that there's a difference between a patent being essential to a standard and essential to the technology. Patents that are just merely essential to the standard are similar to those that are used in establishing railroads. This has to do with track gauges, signals, how wide the rails are. These are agreeing to a common language, and there are multiple different ways that can be that the problem can be addressed. But the real value comes from everyone adopting the same protocol to address it. This is different from patents that are essential to the technology, which in the case of a railroad would be the train engine. That is something where, at least when it was first developed, there really was only one way of doing it. And without that core patent and that core technology, there's no standard to implement. And the holder of that technology could say, you know what, I'm not going to contribute. I have no interest in contributing this. I am going to exploit my unique technology by myself, and that is within their rights. This is why during the standardization process, companies are able to withhold, say, I am going to not contribute certain technologies into the standard, and that is fine. Now, once a patent is put into a standard, however, it creates a specter of holdup. Because once a standard is set, the alternative approaches that could have been adopted during the standardization process are no longer available to manufacturers that implement the standard. And if a standard is broadly adopted, this problem is exacerbated further because there are no viable alternatives to the entire standard. Products built using the standard thus face very high switching costs. They can't simply design around that one patent. They have to design around the entire standard, which can be prohibitively expensive. This creates what's called a lock-in effect that for manufacturers, based off of their prior research and development costs, their manufacturing, their marketing, and certification with the standard of that, they've put a lot of money into developing these products. If a patent holder wanted to and was allowed to, they could use their ability to exclude to capture value well beyond the economic value of the technology claimed by their patent. This would undermine standardization efforts by making it too costly to participate in standards and discourage adoption, which would thus eliminate all of the benefits of establishing a common platform. Now, because of the threat of holdup, competition authorities around the world have been very active in preventing the abuse of standard essential patents. Starting in the 1930s, when ANSI first allowed patents, and they were very clear. And the ANSI is the American National Standards Institute, and it was actually their predecessor organization. They were clear that the patents couldn't be used to advance, to allow monopolistic tendencies. Then the US court started addressing the abuse of patents in standardization efforts in Hartford Empire, where a group of companies got together and created what became a standard method of doing something, and then used their cross-licensed intellectual property to exclude competitors. The Supreme Court there held that although the companies didn't have to allow their competitors to use the technology for free, they had an obligation to license it under antitrust law under reasonable and non-discriminatory terms. This is what ultimately evolved into the FRAND commitment. And over the following decades, there were several developments and cases that really shaped what ultimately became the FRAND obligation. So the objective of the FRAND commitment, which has been adopted, which a variation, whether it's FRAND, fair, reasonable, and non-discriminatory, or reasonable and non-discriminatory, has been adopted by many standards organizations around the world, and has become the norm for standards that are willing to allow their contributors to license their patents for royalties. It has evolved, and this is a very critical point. It evolved out of and in conjunction with competition law. It is not there to supplant the role of competition enforcement. It is there to provide guidance to members of how to ensure that that licensing of standard essential patents is consistent with competition law principles. A violation of FRAND objectives can be an independent violation of competition law in addition to a breach of contract. The other part is that FRAND is supposed to make sure that any company seeking a license to a standard essential patent is able to have market access. It is also there to prevent material discrimination against small and medium-sized companies, and particularly emerging and potential competitors who would like to access that standard. Finally, and in the case of standard essential patent disputes, one of the core issues is that FRAND serves to cap the rate of the value of the claim technology compared to the available alternatives. And the FRAND rate cannot include value attributable to unpatented and unlicensed technology in the standard. The value that has been developed from the standardization efforts from all of the engineers working together to establish the common language, as well as the adoption of the standard, where the network effects and usage by consumers make the standard even more, provide more valuable to the users. And finally, it cannot capture the downstream investments in developing products, as well as the innovative uses of the standard that result from the companies that adopt the standard and bring products to market. Now, these objectives are laudable, but there are limitations to the FRAND commitment. The European Commission recognized over a decade ago now that despite the FRAND commitment's ability to influence SEP holders' incentives to not abuse its intellectual property that's been adopted by a standard, they do still have some ability to do so. There are three, and this occurs to this day. There are three mechanisms that working together really allow this. The first is there's a power imbalance during negotiations between licensors and licensees, facilitated by injunctive relief. The second and third are an information asymmetry regarding the patent landscape, the variability in essentiality and validity rates, as well as the obfuscation of what the FRAND royalty rates are. Now, the bargaining imbalance comes out of the fact that in any intellectual property negotiation, the patent holder is able to exercise its power to exclude. However, the licensee or the buyer has what's called countervailing buying power, which is the ability to walk away. But once a product is incorporated, once a patent technology is incorporated into a standard, the licensee loses the power to walk away without sacrificing the cost of all of the economic benefits that come out of the standard that are not due to the patent itself. This is tied in with the holdup power that gives the licensor more leverage, and by exercising its ability to exclude when the licensee can't walk away, creates an unfair, imbalanced dynamic in litigation. Courts and competition authorities have repeatedly determined that SEP holders that seek injunctions against a licensee who is willing to take a license on FRAND terms are violating competition principles. Two cases that came out of this are, or along this lines, are the Bosch investigation by the FTC, as well as the investigation into Motorola, both by the FTC and European Commission. Those are just two examples. There are many more. But this sort of raises the question of when is a licensee willing? And this brings us to one of the difficulties in negotiating SEP licenses. of how do you determine when terms are friend. Going to the perspective of what the licensee has to look at, or a manufacturer, they need to take a big picture approach from early on. Manufacturers need to know how much a royalty rate is actually going to cost them, not just from one SEP holder, but from all of them. And there are tens, if not hundreds, in certain standards of different companies holding standard essential patents. This is important for determining whether to even develop a product, whether it will be a cost-effective route, and as well as to determine what the pricing is, particularly if the licenses are going to be negotiated after the fact, because the last thing that a company wants is to find out that they have actually been selling their products significantly below their costs after they've had products on market for several years. Additionally, licensees also operate in competitive markets. And this means that it's important that they are not paying significantly more than the competitors, because this will place them at a disadvantage, both in terms of pricing and having money for future innovation to invest in research. So when a licensee is evaluating whether an offer is friend, they need to have information to determine how the offer fits into their expectations, to the extent that they have them, of an aggregate royalty, which requires both knowing the relative strength of the portfolio compared to the overall patent stack of the thousands or hundreds of thousands of declared essential patents. What the implied royalty burden from that will be, and what others, particularly their competitors, are paying for that portfolio to make sure that they are not being put at a competitive disadvantage. Now, this leads to several different problems. The first is there are challenges in assessing the relative portfolio strength. There are many different standard development organizations, and they have similar but different intellectual property policies. And this also goes to how patents are, how those commitments are made. Some organizations, like the European Telecommunication Standards Institute, which is responsible for a significant part of cellular, requires participants to disclose all potentially essential intellectual property rights during the standardization process. Failure to make these specific disclosures can, in some jurisdictions, make the patents unenforceable even under FRAND terms. As a result, there has been a very high rate of disclosure, with over 100,000 patent families having been declared essential to 5G to date. This is just the 5G standard. However, studies have shown that as many as 90% of those declarations and families might not actually be essential. For a licensee that is faced with this, means that there is a very good chance, if you are shown a standard essential patent without knowing more, that it is not going to be essential. Other standard development organizations like IEEE, which is responsible for Wi-Fi, allow what's called a blanket disclosure, where the participants simply have to make a commitment to license their patents on FRAND terms, or a refusal to license them on FRAND terms during the development process. The problem with this is that it makes it very difficult when a licensee is approached with a portfolio to know what else is out there. If someone has 5 patents, or says they have 5 essential patents, well, 5 of how many? So determining the actual patent landscape requires a significantly deeper analysis of reviewing all participants' patent filings and understanding what could be an essential patent that's out there. This has led to leads to an asymmetry in the ability to assess portfolio strength. Licensors have a systematic advantage in this area. A patent licensor only needs to make the investment once and needs to invest in knowing the value and strength of their portfolio. Once they make that investment, they will use that research and knowledge in every subsequent negotiation. They don't need to. There's value of scale that comes from it. A licensee, on the other hand, has to invest in each portfolio of each licensor that approaches them, and that investment really is only useful for that particular negotiation. Moreover, while the licensors have their patents as a result of the participation in the standard development organization, they have institutional knowledge of how the technology functions. Many licensees, particularly SMEs, purchase their modules from suppliers and then are approached for a license by the patent holder. These companies don't have the internal technical, haven't had to make the investment in the technology. And in fact, one of the benefits of standardization is they don't need to, and they can invest in downstream innovation and creating more competitive products. So this puts them at a significant informational disadvantage. There has been some of them will say, well, we purchased our module from this company. You tell the licensor you should go negotiate with them to have them deal with the license. However, licensors will say we can license to whoever we want, and as a U.S. court in the FTC v. Qualcomm noted, licensing at the end product level can be humongously profitable. In addition, there is opacity with regards to rates. Evaluating both the total and bilateral FRAND rates is difficult. There are no guidelines over to what aggregate rates should be. Some companies at licensors will, early in the standard development process, may say, we think that the total aggregate royalty will be $1 per unit or set some rate. But those are simply their impressions and have nothing to do with what the actual market will bear with regards to that technology, and how valuable both the technology, the overall standard, and how much value the patents will actually contribute to that value of the standard, because that is early on in the process. Additionally, many licensors adopt what are called rack rates, which are a publicly declared term of saying we will charge $5 per unit. But their actual rates may be significantly lower. In fact, as the CAJE in their recent investigation have noted, in the context of Ericsson, no one appears to pay anywhere close to what Ericsson's publicly declared rack rate is. And as a result, that itself creates a distortion for the uninitiated. A report out of Europe found that 100% of licensees find that there's insufficient transparency about FRAND royalties, where only 19% of patent holders and licensors believe that that is a problem. In addition to the problem with rack rates is a lot of SEP holders refuse to, even where they do negotiate, will refuse to negotiate until a product has entered the market and a company has made significant investments in the technology. Courts in the UK have observed that as a result of the sort of problems with rate opacity, smaller licensees end up paying a much higher per unit rate than the larger licensees. The same courts have also speculated that these smaller companies are being targeted not because to generate revenue from those license agreements, but simply to extract terms that can be used in negotiations and litigation with larger players. Additionally, in a lot of cases, during the negotiation process, the cost of litigating and negotiating for a FRAND rate for smaller licensees may significantly exceed any savings from actually obtaining FRAND terms. As a result, this feeds back into this asymmetry where smaller licensees are being forced to, and emerging companies are being saddled with excessive rates that are well above what the terms that are actually FRAND. Now, going back to willingness and sort of broader information asymmetry, the reason why this is important is that information asymmetry between buyers and sellers, when it's systematic, can lead to what economists call a market for lemons. The market for lemons was a theory that ultimately won the Nobel Prize, but emerged out of conceptualizing the used car market, where a used car dealer will know the quality of the vehicle, but the buyer won't. Where in an ideal market, both the buyer and the sellers have this symmetric information. There's no viable path for the seller to inflate the rates above what the value of the product actually are. But when the buyers can't verify the quality of the product in an economical way to see if it actually matches the price of what the seller claims it should be, the seller has an opportunity to inflate prices, and as long as the amount of inflation is consistently below the cost for the buyer to investigate the product quality. This forces the buyer to assume that the seller is overpricing the product, which ultimately forces the sellers which are acting in good faith to either inflate their prices knowing that they are going to have to negotiate down or simply exit the market. This undermines trust and market efficiency and makes investment significantly more difficult. This is the problem of what's occurring in standardization, in standard essential patents, where licensees need to presume that the rate is being inflated above the terms that are FRAND. This has been often the case when courts actually look at actually adjudicate FRAND terms, find that the initial royalty demands are 10 or even more than 100 times what the actual FRAND rate is. Going back to the willingness paradigm we were discussing earlier, this leaves licensees in a bind because it is impossible for many of them to know whether an offer is FRAND when it's first brought to them, even if it is supported by comparable licenses or patent landscape studies. They simply don't have the information until a court adjudicates what the actual FRAND terms are. This, as some courts in the UK have also started to observe, that the idea of determining whether a party is willing before a rate has been adjudicated really it creates a a catch-22 situation, and that really once a court says this rate is friend, that's when the question of willingness really becomes an issue. I'd like to thank everyone for their time today as I turn this discussion over to the panel. Thank you very much, and hope everyone has a good day.
Thank you so much, David. Well, David has certainly set up our talk well. As you can see from his presentation, there is so much that we can learn from around the world, and there is a lot of experience that has been kind of put into this SEP licensing landscape globally. And so today, to kind of build on what David kind of talked about and some of the harms that have been kind of evidenced through cases and studies around the world, we want to kind of talk about the global perspective and there's no one better than the folks here today. So I'll just briefly introduce our panelists. We have Enrico Bonadio, who's a law professor at City St. George, London, University of London. We have Christian Helmers, who's a professor of economics at Santa Clara University. We have John Mulgrew, who's an attorney at Magame IP. And we have Gemma Trainer, who is a senior associate for IP at Hogan Lovells. So thank you all for being here today. I want to start off the discussion by talking about a few landmark decisions in major jurisdictions that have really developed their SEP landscape. So I'm talking about mainly the US, the EU, and the UK, wondering how they've significantly influenced the SEP licensing landscape. And so I was wondering if Enrico, Gemma, and John, and either of you can go first, whoever would like to, but could you each discuss a pivotal case from your respective jurisdictions, or the jurisdiction that you have the most experience with, and its impact on the SEP landscape. Additionally, what are the broader economic implications of effective SEP licensing, particularly for emerging markets like Brazil? And so maybe, Enrico, can we start with you?
Yeah, yes, thanks, Priya. Thanks so much for the invitation. I would start with some very recent cases occurred in the UK. In the latest months, there have been several court of appeal decisions on, for example, FRAND interim licenses, which seems to be the new normal now in the UK. In this jurisdiction. So basically, the idea is that the judge, and there have been cases like Panasonic's Xiaomi and the Lenovo, and today a decision has been handed down in the ZTE versus the Samsung case, again on FRAND interim license. I think this is a very interesting development of British case law, basically with the court declaring that a FRAND interim license is welcome, and therefore a licensor who does not want to commit to a FRAND interim license while the proceedings goes on, right? Because, these proceedings are very long, there are technical trials, and they might last very, very, for years, and therefore it would be quite disruptive for the standard user to stop and to suffer the consequences of injunctions. And that's why what the Court of Appeal has done in these 4 cases just in the last year is to establish a new principle, let's say, while waiting for the final decision on the merit, whether there is infringement or not, whether there is essentiality, validity, all the issues that normally are tried in this kind of cases. Before doing that, let's avoid issuing injunctions, because injunctions are often requested by some patent owners in order, to get a weapon, right, which could be then used against the standards users. And therefore, the position of the Court of Appeal in this case is quite clear. Look, especially when there are injunctions requests from the patent owner in different jurisdictions, because here we talk about multi-jurisdictional litigation, which often are in parallel, right, in different countries. So the Court of Appeal of the UK has been clear: if there are patent owners which are seeking injunctions abroad in order to use them as a weapon in order to then impose or try to get a very high licensing fees, well, that would not be good. Instead of injunctions, so instead of it would be better to give licensees, to give standard users from the interim license, because at the end of the day, this is the main target, right, of patent owners, which is to get royalties from the use of their patented technology. So, for example, just with reference to the decision which has been handed today in ZTE versus Samsung, I read it probably 20 minutes before this webinar started, and basically Justice Mellor from the UK court found that ZTE acted in bad faith by using injunctive relief across multiple jurisdictions to pressure Samsung into accepting the Chinese forum from Farhan determination. And the court characterized this behavior as an hold-up behavior, noting that ZTE was holding out an olive branch with one hand and a sword in the other. So this metaphor makes us understand very clearly what we're talking about here. So the judge in this decision of today rejected the argument of the patent owner that their jurisdictional preference was legitimate, finding that a willing licensor would not start unnecessary injunctive proceedings when the licensee was actively seeking fresh global front terms. I mean, that's the useful purpose of interim license, right? And therefore, I think this new trend could be, let's say, followed also by other courts in other jurisdictions, right? It seems the new fresh trend, which makes perfect sense to me, because it is a win-win situation at the end of the day, because of course the patent owner, while waiting for the decision on the merit, the final decision, gets royalties. On the other hand, the standard user does not stop its business, continues, and then there will be some adjustment, of course, right? At the end of the final decision on the merit, if the implementer has paid less or more, this could be adjusted. So it seems to me that this trend, which is now emerging from the UK courts, could really be followed as an example in other jurisdictions, because it tends to avoid confrontation while instead promoting a more friendly relationship. Of course, it's something which is kind of imposed by the court. It's a declaration, right? And of course, if the patent owner does not follow that declaration, there might be consequence of being considered an unwilling licensor and acting in bad faith. So yeah, I stop here because otherwise I monopolize. But I think this is the most important recent developments from UK case law.
Thank you, Enrico. And I just wanted to make one comment about the interim license. I think it's really interesting too, and maybe a sign that this is one potential positive solution, because other jurisdictions like India, for example, have been doing a very similar practice with pro tem security deposits. So it is very interesting to kind of see now a very similar solution, interim solution being applied in the UK, and seeing how that kind of plays out. So thank you for that. Maybe Gemma, can I throw it to you?
Yes, absolutely. Thank you so much for having me. I just want to say before I start that anything I talk about today are my own views and they're not the views of my firm or any like clients that I'm representing. But I sort of want to take a slightly different approach from Enrico, but I think it's very much linked in that the case I wanted to talk about is Unwired Planet. It is the first UK case that set rates. And I think fundamentally the sort of golden line that goes between Unwired Planet and the interim license cases is that the way the UK court sees these disputes is that what is really going on is not a dispute about a particular patent. It's ultimately a dispute between parties about what the terms of a FRAND license should be. And so the solution that the UK court sets and the remedy that it sees as being the appropriate remedy is the financial remedy of what the license should be. So Unwired Planet was an infringement case originally brought by Unwired Planet against Samsung and Huawei. And following findings of infringement and validity on a few of the patents, the UK court went on to consider FRAND terms and set the terms of a fully executable license. The decision established that the UK courts would look at the FRAND commitment contractually, so different to the Huawei ZTE competition-based approach favoured in Europe. So the court looked at the ETSI IPR declaration as a third-party beneficiary contract, a contract between the SDO and the SEP holder for the benefit of the third-party implementers who are implementing the standard. And in determining the FRAND royalty, the court looked primarily at comparable licenses to derive the appropriate rate, and for Huawei's devices and infrastructure, and it ended up specifying ad valorem rates. And the court also performed a top-down cross-check in checking the rate that it thought was appropriate. And importantly and controversially, and again, I think this goes back to the sort of constant thing with new cases, that one of the most interesting and debated points of Unwired Planet is that it set a global rate for UK SEPs. So Huawei lost the argument that a UK-only license would be FRAND. And the main message, of course, coming from Unwired Planet, which the UK courts have continued to mention in more recent cases, is that courts in interpreting the FRAND contract should look at industry practice and commercial practice in the real world when assessing FRAND terms. So for instance, in that case, the court set different rates for different jurisdictions for China because that was based on the evidence of the comparable licenses. The court also developed the concept of the FRAND injunction. So once the license was settled, Huawei needed to elect between taking the license or accepting an injunction, which is the normal remedy for patent infringement in the UK. And the court decided that the final injunction should be effectively a conditional injunction, a FRAND injunction, that would be lifted in the event that Huawei took the license. And this concept has been developed in later cases. The position is now that the implementer has to elect between taking the injunction or taking the FRAND license at an earlier stage. So once the first finding of infringement and validity at first instance is handed down. Unwired Planet was ultimately appealed all the way up to the Supreme Court, and the Supreme Court of the UK confirmed the court still have the power to grant an injunction to prevent infringement of SEPs and to determine the terms of a global license by construing the ETSI declaration. And you know, Unwired Planet had obviously a very significant impact, I think, not only on UK litigation, but on litigation globally. So in the UK, many SEP holders subsequently brought cases seeking determination of FRAND licenses. There have been 2 further FRAND determinations, so InterDigital and Lenovo and Optus and Apple, as well as many more cases that have settled before going to full trial. But significantly, because of the remedies offered by the UK court in setting the license, implementers have also started bringing cases seeking determination of FRAND terms, and this is where the case law around the interim licenses really comes to the fore. So this may be partly due to the fact that in some of the more recent cases, the rates determined were seen as being, well, they were much less than the SEP holder had originally wanted. But I think a key factor is that the UK is also a forum where the terms can be determined, because obviously while the parties are always arguing about the price, the terms and the scope can be very significant, and the UK offers a forum where that can be debated and ultimately determined by the court.
Thank you, Gemma. And John.
So we've all picked the same country to talk about. I had picked InterDigital versus Lenovo, but I think what you're hearing is the tension in the different court systems is very real. And as David set this up very well, that there are courts that turn to injunctions to force resolution. I'll use that term very loosely, to force resolution of an SEP dispute. Typically under the terms, whatever they are, in the license for the licensor, and that process avoids figuring out what is the fair price to pay. So the flaw in the alternative to what the UK has been doing with rate setting is that it leads to unchecked potential abuses by licensors. Now, there are a lot of licensors that are very good at what they do. They take their FRAND obligations very seriously. So I'm not trying to suggest that all licensors are bad actors, but certainly there should be mechanisms to ensure that both the licensee and the licensor are meeting their obligations. And with an injunction-based regime, if that's your legal system, I really don't see many mechanisms to ensure checks and balances on licensor behavior. And so I do think interdigital, I mean, I was at Lenovo. I worked directly on the interdigital negotiation, so I won't be getting into any of those details. But I think that case is the beginning of a new. I mean, I do think Unwired Planet is the beginning, the real beginning of the shift. But I think interdigital was this turning point where licensees, I think, felt like there is another way to go. And one advice I would give to licensees, and I think we're already seeing this in practice, is if you feel like there's an abusive licensor who's not really offering a FRAND compliant license, do not wait to be sued. In some jurisdiction where you'll be enjoined, you should just go ahead and go. There are places to go where you can get the rate set. And if you really are truly willing to be a licensee, the obligation, so there's an obligation that you're willing to pay what the court decides. That I think is a very good check on licensees to make sure that they're serious about taking a license. But if you are, then a rate setting action is by far the superior outcome to an injunction outcome. And also, you have the greater benefit of transparency for other licensees to see what is fair. I think overall, a system that has transparency on transactions allows for less litigation, faster transactions to happen in the future, less fighting. We're in a system right now where both sides complain about the other side, and that there's no greater sign that there's something wrong than everyone complaining about the system. So in the interdigital case, I would just say that, from my perspective, Interdigital is a publicly traded company, and it is possible to review their quarterly statements and see their royalties coming in. And so, from my perspective, what I thought was a basis for a fair license was looking at the income statements from Interdigital. And I personally, not speaking on behalf of Lenovo here, I felt that we needed a rate setting action in order to have somebody break the tie between us and the other side. And so I feel like the rate setting action, Lenovo didn't win everything they wanted to, they didn't lose everything they wanted to, but I think the outcome is a good outcome. And I think that process with interim licenses now as a more recent development, I think it is a very interesting way to resolve SEP disputes that are not only good for the parties in the instant dispute, but it paves the way for future disputes to be simpler and to be resolved faster. So I do think this is an interesting development. I would encourage any jurisdiction thinking about rate setting should really try it, because it is a vastly superior way to resolving these disputes than just giving an injunction or punishing the licensor and having them have some severe outcome. Those solutions are not as good as having the rate to be set.
Just to add to,
Go ahead,
sorry, just to add to that, and just thinking about the economic consequences for Brazil, I completely agree with what John says, because while injunctions are obviously an attractive tool for SEP holders to be able to persuade implementers to take their preferred rates, what is good business for the court, in inverted commas, is not necessarily good economic business for a country. So, I mean, likelihood of injunctions affects decisions about where implementers base their operations, results in less investment. Piecemeal infringement issues are more likely to result in newer technologies not being available while infringement issues are being ironed out, and ultimately, less implementer investment in a market means fewer consumer choices, and that's generally not a good thing.
Thank you, Gemma. I want to now turn to one very important topic that we can think about from an economic perspective. So a major challenge in SEP licensing is the self-declaration of essentiality. And this was something that David had touched on in his presentation. And this self-declaration can lead to over-declaration and portfolio bundling, and not being able to kind of know as the licensee whether the license that you're being offered is truly essential. So Christian, based on your research, and how prevalent is over-declaration, and what are the consequences of standard development organizations not conducting independent and consistent essentiality checks, in your perspective?
Thanks, Bria. Yeah, so I think there's no doubt that the problem exists. There are very different estimates about the extent of over-declaration in practice. I think these widely varying estimates, they're due to, of course, the different standards, and also, I think, difference in opinion or what really constitutes essentiality and how to assess that. But the bottom line is that, the estimates range from maybe less than 10% of declared patents being actually essential, way up to maybe 80%. But it's clear that over-declaration exists in practice, and David already explained it, but it's really important to highlight the importance of over-declaration. So if you think about, a standard top-down approach when determining friend rates, it really matters how many patents are declared standard essential when you compute your royalty rates. So that makes it very clear that SEP owners have incentives in principle to inflate the absolute number of patents that are declared essential. That being said, I think it's really important to understand the reasons for over-declaration. And I think a lot of it has to do with the timing of declarations. At the time most of these declarations are made, the patents and the standards are still evolving. So patents, as you probably all know, evolve during the examination process. And this is particularly true, I think, in the standard context, because we're talking about international patent portfolios. So it's expected that patent claims will evolve differently in different jurisdictions. So the UK patent at the end of the process will look different from, say, the Brazilian or the Chinese equivalent. And that has implications for essentiality of these different family members. Another reason, I think, is that the standards themselves, they obviously continue to evolve. So something that might have been initially standard essential might over time no longer be standard essential, or at least not to the same degree. So often these declarations, when at the time when they're made, they are some type of prediction rather than a binary assessment. And then there's obviously also a case-specific element that a particular licensee, for example, might actually not use certain features of the standard for the product that they're manufacturing or selling. So that then introduces yet another very specific element in that equation. But then finally, I think there is the issue that is of most concern, which is opportunistic conduct. So there is definitely a concern that firms might over-declare simply in order to inflate the royalty rate that they can charge licensees. But you can see that these different reasons for why over-declaration exists are really hard to separate in practice. Right? And that makes this a really challenging problem. Nevertheless, it's also important to highlight that over-declaration in part exists because standard setting organizations and SEP owners, I think they're really worried about the opposite, which is under-declaration, because they might then be accused of, for example, patent ambush. So there are actually a whole range of very legitimate reasons why over-declaration exists, and why firms have incentives to rather err on the side of over-declaring than under-declaring. Nevertheless, in practice, it causes significant problems for licensees. So then the question really is how to deal with that. So the consequences of a declaration are relatively clear, right? They create uncertainty and they make it more difficult to agree on price points. And I think John pointed to that. One of the biggest problems we're currently having is that price points diverge very significantly between licensors and licensees. And one contributing factor is certainly a disagreement about which patents are truly essential and therefore should be part of a portfolio license or a licensing agreement in general. I don't think there are any good solutions to date. Of course, there's the hope that AI will make it easier, faster, and cheaper to make essentiality assessments at the time when needed, meaning when there is a negotiation for a license. Obviously, the EU also had ideas about third-party assessments. In Brazil, for example, as far as I know, the courts can appoint experts that then provide a third-party independent assessment. So there are different solutions that are currently being proposed to the problem. UK courts have just relied on third-party data, existing studies to make relatively ad hoc assessments. That is certainly also viable. So it remains to be seen what can be done about it. But there's no doubt that it is a problem, but it's important to understand it's a structural problem that is not simply due to opportunistic conduct by licensors, and if they just behave differently, it will go away.
Can I just add a few comments here? Is it okay?
Yes.
I think there's really three places where you can improve standards essential patent licensing. One is at the standards organizations within themselves. And so at this SDO level, you could do a lot of different things. It is possible to have a standard organization say at the beginning, we're going to have the next generation of whatever the technology is, and we all agree that the aggregate royalty is $1 or $5 or whatever. You pick the number, and then people can participate or not participate, knowing in advance that they're going to get a share of the aggregate number, and there'll be some mechanism for doing that. That's one way that a standard setting organization could address this profound licensing problem across multiple industries. Another way is to do with the essentiality checks. I feel like the disclosure of patents during the standard setting process feels about right to me. Like as you're disclosing things and contributing them to the standard, you're also maybe disclosing or declaring your patents as possibly relevant to the standard. So that feels right. But we don't have a mechanism to come back later and say, well, now that all the dust is settled, here's what really matters. Here's what's really in my portfolio. So you could have an aggregate royalty process that just avoids essentiality checking, but you could also, because there's such an economic incentive to the licensors to come back and verify or do some process. And I think SDOs could require that of their members. But instead, they have chosen not to do anything in large cases. And so that's put more pressure on the other two mechanisms, which is a regulatory approach or a court-based approach. And so because SDOs are really not doing much to solve this problem, you see a lot of court activity, which is, I think, inferior to an SDO solution. If the industry could solve the problem themselves, it would be far easier, but they're just not. So thank you for letting me add those comments there. Sorry about that.
No, that's perfect. Before I move on, does anyone else have any other thoughts on this? Okay, great. John, that actually does a very good job of leading into my next question, because I think we can kind of look at it in different layers. You know, what can the SDO, the standard development organizations do to kind of clarify this landscape? But of course, we're not seeing that from the SDOs. We're not seeing these certain implementations mechanisms that have been suggested. And, you know, some of that obviously is because these are technical experts that do not want to get into that, essentially. And so we have regulators and we have courts that kind of handle this. And, you know, at least in one jurisdiction in the EU, there was a proposed SEP regulation that very much went it went very far in the process. It was approved by a supermajority of the parliament. It was very well supported. Of course, there was discourse about this regulation, but I know, Enrico, you have been very integral in commenting on the regulation and kind of diving into the regulation that was proposed as a soft intervention by the EU. So could you kind of give us just an insight of what were the key provisions of the proposal, and in what ways did it aim to address shortcomings of current SDO practices?
Absolutely. The proposal was withdrawn just a few months ago in February 25 due to lack of consensus. It aimed to address significant shortcomings in the current SEP licensing practices through a comprehensive reform. So, for example, the key provisions, it would have established a central SEP register managed by the European Union Intellectual Property Office based in Alicante, requiring mandatory registration of SEPs with detailed licensing information. Essentiality checks would have been secured by independent evaluators, which would verify whether the patents were truly essential to the standards. This is a very important gap, which has been highlighted in previous talks, especially at the beginning by David. And then also a key provision was the FRAND determination procedure, which would enable out of court, or at least facilitated out of court resolution of licensing terms before litigation. And the framework also included more transparency requirement, forcing SEP owners to disclose royalty policies, patent pool availability, and court decisions. And also provisions in favor of SMEs, small and medium-sized enterprises, offering simplified procedure, exemptions from complex requirements, and potentially royalty discounts for SMEs. So the shortcomings that these proposals aim to address, information asymmetries between patent owners and implementers. This is very important, especially for SMEs, which do not have the financial capacity, of navigating this landscape in the very same way as, big multinationals. So implementers here in this scenario often struggle to identify relevant patents and licensing terms. So this proposal aimed at preventing, or at least making more difficult patent holdups and patent ambush situations where SEP holders could demand excessive royalties. Of course, the lack of transparency and the other gap, because this is a gap in current licensing practices, as we have said. The regulation also sought to reduce the litigation costs and delays by establishing the dispute settlement resolution mechanisms, and of course market access barriers would have been probably removed or minimized, especially for, as I said, SMEs lacking resources to navigate this complex licensing landscape. So despite the withdrawal, several EU member states, as far as I understand, including Germany, France, Italy, continue pushing for discussions. Politically, there has been a new commission being elected, because last year, after this proposal was put on the table, there were European elections, and therefore another commissions with other commissioners. When these things happen, of course, the consequence could be the withdrawal of an important piece of legislative draft. So this is the state of the art. I really hope that it could be resuscitated, maybe in an amended form, because at the end of the day, we need, in my opinion, we need to make sure that these kind of patents are addressed differently. They are different kind of patents. We cannot hide ourselves behind the finger. And also, this could be an example to follow also for other jurisdictions, including Brazil, because as far as I understand, until now, or until very recently, there was no distinction, and there is still no distinction in the legislation between normal patents, traditional patents, and the standard essential patents. These are sui generis patents which need particular attention. I stop here because I don't want to monopolize again, but I could talk more and more.
Oh yeah, absolutely. No, thank you so much, Enrico. That's really helpful. And I want to throw this question out to whoever wants to answer it first, just to all the panelists. So, you know, we've talked to Enrico just talked about the EU and how they were proposing an implementation of this soft intervention regulation and some of the core key concepts that were in there. It would also be helpful to talk about what competition authorities around the world have kind of done to address this issue. So as we've talked about in the previous webinars, and as we know, the FRAND commitment is intended to balance patent rights and open competition. It's intended to support competition within the technical standard. I want to ask any of the panelists, how have courts and competition authorities in you know, any jurisdiction, but maybe also focusing on the major jurisdictions that have really dealt with a great deal of SEP licensing disputes, the US, the EU, and the UK. How have they addressed antitrust concerns in SEP licensing, and where do you see the gaps or missed opportunities in their approaches that maybe Kajay can kind of pick up on?
I'm happy to talk a little bit from the UK court perspective.
Sure, perfect.
So in the UK, so as I mentioned when I was talking about Unwired Planet, the courts look at FRAND as a contractual issue. It's the FRAND price that the SEP holder has promised to give, and that is not a competition analysis as is done in some jurisdictions. And so it's still open to parties to allege abuse of dominance in the context of FRAND cases. But so far, this hasn't been successful in cases where the SEP holder has been willing to offer a license on FRAND terms. Now, that doesn't mean that dominance issues and competition issues have no role to play in future cases, because they would probably arise where a SEP holder is refusing to offer a license on FRAND terms. Now, as we've had more implementers bringing cases seeking FRAND determinations and SEP holders not saying that they will commit to rate determinations, it may be that there are some abuse of dominance issues that will be played out in future cases. There may also be abuse of dominance issues and competition issues where there's a genuine dispute between the SEP holder and the implementer about exactly what patents are covered. So if there are agreement on certain SEPs and agreement on potentially not other patents or related patents that could frustrate the operation of the SEP license. And Unwired Planet did consider abuse of dominance issues, and other cases have considered them, and it sort of very clearly kind of put it in a hierarchy, in the sense that it said that a FRAND rate is not a rate that there is no sort of, the abusive rate and FRAND and the non-FRAND rate are not similar. It's effectively in a ladder, so an abusive rate would have to be much higher than just a purely non-FRAND rate. And I think the court said it's only an offer which is so far above FRAND as to disrupt negotiations that would fall foul of Article 102, so the abuse of dominance provision. So it is a sort of issue that is kind of in the background, but in the UK kind of cases, it's not been at the fore because it's done by way of a contractual analysis. And just to finish, it also obviously raises issues going back to what Christian was talking about potential risks of under-declaration. There are obviously potential issues if there's a patent which hasn't been declared, but which is technically essential.
Enrico, I know that you focused a little bit on the European Commission's intervention on the HMD v. Voice Age case in Germany. Can you kind of talk about how the competition authority in the EU has kind of played a role in this?
Yes, basically what the Commission tried to do with that intervention, amicus brief, was to, you know, to highlight a certain divergence in approach from national courts in the EU member states following the UAE guidelines of 2015, which have been mentioned by Gemma before. No, 2015, we had this landmark case where the Court of Justice basically found that, you know, seeking an injunction when you are in a dominant position without taking necessary steps could be an abuse of dominant position. And in that decision, the Court of Justice has established a roadmap, let's say, some negotiation guidelines which should be followed by patent owners and implementers in order to avoid, you know, anti-competitive behavior. The problem is that such guidelines of 10 years ago now have been applied in different way in different countries, especially in Germany. It seems that the German courts have a bit distanced themselves from that framework, right? And therefore, in that opinion, the Commission, you know, highlighted these. And probably the way out of this is to make a fresh referral to the Court of Justice for another interpretation of, you know, of these guidelines, right? It's important because those guidelines were established 10 years ago. In the meantime, you know, the licensing landscape has, you know, has evolved, and therefore there is the need, in my opinion, of another clear, you know, interpretation by the Court of Justice, because it's important that the courts from national member states adopt similar, if not, you know, harmonized procedure, right? And it seems instead that, for example, German courts have kind of watered down a bit that, you know, that framework in favor of patentees, in my opinion. So, but as you may be aware, that opinion has not really been followed by the German courts. And probably it has been perceived as a kind of invasion into the domestic, you know, into domestic proceedings by German courts. But the problem remains, and the problem remains of a divergent interpretations of those guidelines. We need a fresh proposal, a fresh referral with another ruling of the Court of Justice clarifying the issues.
Thank you. Does anyone else have any thoughts about this question? Okay. So moving on now, we can kind of bring in the Brazil perspective now. So as we know, CAGE's investigation into Ericsson's SEP licensing practices marks a significant shift towards treating SEP disputes as a matter of public interest in Brazil. John, can you talk about, and whoever else would like to comment on this, what potential impact could this case have on the future of SEP licensing and litigation in Brazil?
Sure. So I will say that I was involved in the Ericsson negotiations and part of the litigation as well. And I think David did a really good job commenting on it in his opening remarks and talking about many of the policy points for why investigations are needed as a check on abusive licensors. So I'm not going to really talk about Ericsson directly. I'm going to talk more generally about what a healthy licensing system should do, especially in a jurisdiction where injunctions are the remedy, are the way to resolve the dispute rather than a rate-setting action. So, like a healthy standards essential patent licensing regime should have checks on abuses by either party. So, of course, if the licensee is not a willing licensee, the check is that there's the ability to get an injunction against them and have them denied access to a market. It's a very heavy check against unwillingness of a licensee. Likewise, there need to be checks on licensors, especially again in an injunction type of jurisdiction where there is potential for abuses by licensors that if not kept in check, you could have very wide outcomes in what the licensees end up having to pay. And again, I think David commented pretty well on this, that there are wide variations in licensor outcomes, especially in jurisdictions where injunctions are the solution. So a healthy system should have a way to check on the licensor to make sure the licensor is actually being legitimately following its FRAND obligations and not being abusive towards others. So if you have a rack rate, for example, that is $10, but you always license for $1 or less, then to demand the $10 amount could be seen as an abusive practice, just giving an example in general. And so one way to do this, to check on these abuses, is there's two ways I see to address these potential abuses. One of them is very difficult for the licensee, and one of them is this intervention by having an investigation. So one option would be for the licensee to have a rate setting action, go somewhere else and have initiate a rate setting action, which is the trend that you are seeing in the industry. People, licensees are going to the UK more often because that's one of the few places to go to have a rate setting action set, and that puts you in a race between, say, Brazil and the UK to figure out who will resolve the dispute first. And so it's a very expensive prospect for licensees to have to litigate in multiple jurisdictions, and it really doesn't directly address the licensor's behavior. It only gets you to an outcome where you'll get a FRAND result, but you won't have any correction on the licensor behavior. You'll leave that licensor to use the same tactics against every other licensee in the future. And then the other option is to have investigations into the licensor behavior. And I would like that those types of investigations to be open and transparent, so that licensors, when they are violating their FRAND obligations, every licensor and every licensee is able to see what the violations are, so that we can improve our system overall. Like if we keep everything quiet, like we have when we have an injunction, with a settlement, when there's an injunction threat, informs nobody in the future about how to conduct licenses. And likewise, if there's some sort of abusive behavior that gets resolved quietly, no one learns how to improve the process. So I do think an investigation is useful, especially in injunction jurisdictions like with Brazil. And I would encourage it to be public findings after the investigation is completed. And I'll stop there for the interest of time.
Priya, may I just add
Absolutely.
1 minute? I think what is really interesting in that decision of 2 months ago, not to continue this investigation by the competition authority in Brazil, is the framing competition as a public good as well. And it's not just a matter of competitors, right? Of course, protecting competitors, but it is also and mainly about protecting consumers, about protecting competition as a public good. And also there are many references to TRIPS provisions, very important TRIPS provisions, which like Article 8 on public interest, on preserving competition, Article 40 on anti-monopolistic licensing, anti-monopolistic behaviors, and how to react against licensing restrictions or unfair licensing practices. So it seems that the antitrust authority in Brazil has really considered such important provision of the TRIPS agreement, and they need to comply. No, it's kind of framing this, decision in light of international obligations stemming from the TRIPS agreement, and I think this is important.
Thank you so much. And I am going to allow us to just go 1 or 2 minutes over, because arguably this is the most important question of the panel. I'm going to kind of tie 2 things in for Christian, because I want to get his economic perspective on a very important concept. So my overall question to all of the panelists is, obviously, as we've kind of acknowledged, Brazil is at this pivotal moment in shaping its SEP licensing framework to foster innovation in Brazil and to protect consumer interests. So from all the panelists, I would love to know, what are the main challenges Brazil faces, and what policy recommendations would you offer to ensure a balanced and effective SEP licensing regime? And I want to start with Christian, because I also want him, if you don't mind, Christian, to tie in, and this is something that David had brought up. We often hear terms like SEP or patent hold up and patent hold out, and we also hear about market participants that both practice their SEP while others operate to acquire and enforce them. Can you explain the realities of hold up and hold out in the SEP landscape briefly? And can you also discuss the role of a non-practicing entity in modeling the SEP licensing landscape? So really, just if you can kind of throw in your perspectives on hold up and hold out, kind of in your final thoughts, and then we'll kind of toss it around to the other panelists.
Sure. So David already explained the idea of hold up, which has been a very influential idea generally, but also in the SEP context. And the idea is very simple. If you practice a standard, you have to license the patents declared on that standard, at least in theory. And that essentially means that there are no substitutes to these patents, and that gives the patent owners more power than in other contexts. And the risk is that the patent owners are going to abuse that power to extract super friends, so excessive licensing rates. The mirror image in some ways of this is a concept called holdout. Here it is the licensee that essentially, at least in theory, has the ability to reduce the royalty rate that's payable below the amount that it actually should be paying by, in some ways, just dragging their feet and trying to avoid a license either altogether or by delaying, essentially achieving some reduction in the royalty rate. And the main mechanism here is the friend commitment, which you could say in some ways imposes a ceiling on the royalty rate that the licensor can charge to a licensee, and that therefore then creates some incentives by the licensee to try to reduce that by, for example, litigating, challenging the validity, essentiality, infringement of the patents, etc. So these are the conceptual ideas underlying this debate. In practice, I would say currently hold up and hold out play out mostly in the form of cross-border litigation, where injunctions and friend determinations play, I think, the most important role currently. So that means patent owners try to strategically file cases in certain jurisdictions. And this is where Brazil comes in, particularly in Brazil, as well as Germany, because these jurisdictions, due to their litigation systems, are more likely to grant preliminary injunctions, which then help the licensors to exert pressure on prospective licensees, which can be considered as a form of hold up. Licensees, in contrast, they also have interest in filing strategically in certain jurisdictions, for example, China, obtaining anti-suit injunctions in an attempt to essentially avoid licensing through essentially foot dragging, or I would say, also legitimate, of course, concerns over hold up and trying to counteract that through these strategic lawsuits. This brings me directly to Priya's question about Brazil. So I think Brazil is a really interesting setting because you think globally about patent litigation. I think Brazil really has become very important jurisdictions only over the last couple of years because licensors discovered the possibility of obtaining preliminary injunctions in a relatively large market, which would be useful for global licensing negotiations. As far as I'm aware, in Brazil, no case, or perhaps one case, has reached a merit stage to this point. All other cases essentially have been settled or are still ongoing, which is in some ways indicative of the strategic importance of Brazil as a jurisdiction. So licensors are mostly interested in simply filing in Brazil to obtain a preliminary injunction, which is then useful within the broader context of a global licensing negotiation. And of course, it is in some ways problematic if a jurisdiction is mostly used for strategic purposes and the parties have no real underlying interest in resolving their dispute in this jurisdiction. I think the Brazilian courts have started to recognize this as well, with recent decisions not granting preliminary injunctions or being a lot more restrictive in applying preliminary injunctions. So there is probably some change on the horizon, but I think this is something that the Brazilian litigation system, the courts, will definitely have to think about.
Thank you, Christian. So we're gonna rapid fire, but I want to start with Gemma.
Yeah, so I think I want to sort of center a point that is actually based on one that Enrico made. And I think it's important for Brazil and it's important for any jurisdiction that's really thinking about FRAND disputes. And that is that these are not normal patent disputes. In a very kind of traditional sort of idea of a patent dispute, the infringer is typically seen as the bad actor. It's someone who's taken the benefit of the invention that the innovators come up with. But the standards dynamic is completely different because infringement obviously necessarily takes place where the patent's truly essential. And we need implementers to implement standards in order to provide products that allow consumers to reap the benefits of the technology. And to add to that, SEP holders have promised voluntarily to license their patents on FRAND terms. So I think on a policy basis, I think it's really important for any court and for Brazil as the jurisprudence develops to think that, normal patent remedies shouldn't simply be applied to the SEP context without a specific consideration of FRAND issues. And